Okay, this is Chapter 3 of the State and Local Government course, State Constitutions. So what we'll be doing today is, after we've talked about the U.S. Constitution, we'll be focusing on the individual state constitutions. America has what we call the system of dual constitutionalism, where each state has its own constitution, and so we have both national and state constitutions working at the same time. Recent polls show that almost around half of Americans do not even know, not aware that their state has its own constitution, which is considerably more detailed, as we'll talk about. It talks about the foundation of law that's specific to their state. And much like the U.S. Constitution, it's the fundamental law of that state, and it's superior to any statutory law. Those are laws that are passed by the state legislatures. But again, according to the U.S. Constitution, which is the supreme law of the land, the state constitutions are subordinate to the federal constitution. Now, as far as the historical development of the states in the U.S., each of the original 13 colonies had their own charters that evolved over time, and they obviously had the British model to go by. In as early as 1639, the Massachusetts Fundamental Orders put choice back into the hands of the people. So there was quite a bit of democratic development going on quite a while before our Constitution. The Continental Congress, at the time of the Revolutionary War, instructed the colonies to reorganize their governments based on authority of the people. So they were, again, rebelling against the British Empire and wanted a system that was not going to be a monarchy. The earliest state constitutions, however, were not real democratic, and initially legislative supremacy was the idea, as we'll talk about here in a minute, particularly at the states level. The executive branch has shown a little bit more supremacy. As we see here, growth of executive power has been occurring over time, much as it has with the federal level, in that there's growing disillusionment with the legislatures of trying to get something done. We've got political partisanship going on between the parties. Amendments have increasingly granted more power to the executive. Since the Civil War, 27 state constitutions have been replaced. The Progressive Era was a very productive time as far as reform goes. This was partly as a result of the Industrial Revolution, which we had an enormous amount of technological economic development, but of course there was also a lot of concentrated wealth, corruption, machine politics, the boss rule, where clientelism, patronage, the spoils system was in full swing. So the Progressive Era was pushing back against that to give more power back to the people. The state constitutions have some weaknesses to them, one of which is the excessive length that they get into considerably more detail, with a lot of clauses that may be meaningless or kind of lose their meaning over time. This results in more contradictions within the fundamental law of the state. They are easier to amend generally than The U.S. Constitution, which we talked about, has not been amended very much over the past couple of centuries. And then once it's amended, they're almost there to stay. Now, speaking of the length, this is a chart from the book. You can see the wide variation as far as the number of words in these constitutions. Alabama got by far the longest. You can see the average here as far as the length of their constitutions. The state constitutions call for numerous elected officials, and because of the home rule, states are required to set up their own forms of governments. And of course, they have to break that down into counties and municipalities and towns and village. So as we'll look at here in more detail later on in the class, there's close to 90,000 cities and towns in the United States, and yet the local authorities are still subject to quite a few restrictions. So the basis of the law of the state is handled at state level government, and then certain things are doled down to the cities and municipalities to do, but there are numerous restrictions. And as these constitutions have evolved over the years, we've talked a little bit about how that progressed with civil rights and things like that. We have various unequal treatment of groups in these constitutions. So there's a lot of variation and not a whole lot of time for reform. One of the things that we mentioned in their evolution of our civil rights is that the United States Bill of Rights were initially submitted to appease the anti-federalists and to restrict, put some restrictions and more boundaries on national government. These are the first 10 amendments. Interestingly enough, though, an 1833 Supreme Court decision, Barron versus Baltimore, where Mr. Barron had a wharf or a dock in Baltimore in the city, the state of Maryland. The city took part of his wharf. He needed it for construction purposes, and he said, well, wait a minute, I thought the Fifth Amendment says you can't do that. So he filed suit, and it went all the way to the Supreme Court, and the Supreme Court ruled in favor of Baltimore, or Maryland, so to speak, and said that this Fifth Amendment of the United States Constitution prevents the federal government from taking your wharf. The state can do whatever they want if they don't have that in their constitution. So this reinforced the concept of dual citizenship, which I mentioned a little bit earlier, in that national citizenship is separate from state citizenship, which is a concept we don't even acknowledge anymore. So it took a long time, next 130 years, the U.S. Bill of Rights had to be put back in, at least on a case-by-case basis. The states were then required to comply with the federal Bill of Rights. And this is what we call a long process of nationalizing the Bill of Rights. So regardless of what a state has in its own constitution, they still have to abide by the federal Bill of Rights, Fifth Amendment, the unwarranted searches and seizures, cruel and unusual punishment, those things that we've already talked about. Here's a breakdown of a few of the major ones. First Amendment has 5 provisions in it. Those are some of them right there. Second Amendment, famously, the right to bear arms. Fourth Amendment, you have to have proper search and seizure warrants. Fifth Amendment's a big one. Requires due process of the law. You have the right to remain silent. This is where the eminent domain one is listed, where the government cannot take your property without due compensation. The Sixth Amendment calls for a speedy trial and the right to counsel. Eighth Amendment is cruel and unusual punishment. And then we've already talked about the 10th Amendment, which is the reserved powers to the states. Importantly, delegating all the powers back down to the states that aren't specifically called for in the national government. Now, as we come out of the progressive era, there was somewhat of some unity there of trying to get the state constitutions a little bit more consistent with each other, and the convention came together and came up with a model state constitution in the early 1920s. But it wasn't until the 1960s that every state, since that time, between that period there, every state altered its fundamental law in some respect. And one of the shifts was to what we call this higher law tradition, where we're trying to get a little bit less detailed with more basic and enduring long-term principles, much like the U.S. Constitution, which is relatively short. And of course, now that does bring up some issues of interpretation and perhaps a little bit more vague, but some of the states are trying to shift to that idea as well. Here's the breakdown of the proposed model state constitution, and so you can see what the basic articles are going to cover right there. You can look through those categories, and then just for comparison, we can look at the New Jersey State Constitution, its articles, and you can see how it's followed this relatively closely. And I'm also posting a link on Moodle to the New Jersey State Constitution. I will probably have an exercise where we will look at that. But as you can see, Article 1, Article 2 is looking at elections, and Article 3 is how the powers are distributed. These are the articles that are breaking down the three branches of government. Article 7 here, obviously has to go into more detail than what you would see in the federal constitution as far as public officers and employment. This article here is looking at taxation and finance. So there you can see the breakdown of the New Jersey State Constitution, which kind of followed the model state constitution somewhat. And because all the states are responsible for their own constitutions, we can see quite a bit of variation, and we see that this is just a sampling from the book that shows just some of the interesting excerpts that could come out of their own state Bill of Rights there. There's a sentence from the Montana one. Here's one from Alaska right there. Here's an excerpt from North Carolina Constitution that's what they decided to put in there, so you can look through those as well, just showing you the in some cases quite interesting things that are spoken about in their constitution. Now, as far as changing the constitution at the state level, you do have an informal method of doing that, and this is of course the interpretation of that constitution. And this of course happens on the federal level, where the president may be interpreting the Constitution a certain way in order to provide some sort of act, and the Supreme Court, as we'll talk about in more detail, as to rule on various cases, and they may interpret the Constitution in their way. So on the state level, this is a little bit more common because you've got more activity of trying to get things done at the state level. Executive orders based on his own interpretation. There may be advisors that are providing opinions on how to interpret that, as well as various agencies in the bureaucracy that are having to implement some sort of law, and they may have to provide some interpretation on how to do that. So again, there's lots of people that are implementing these rules and regulations that might require some some variation there. Judicial review is the concept where the courts can virtually strike down a law and can declare a law or any particular action unconstitutional. So that's based on their interpretation of the Constitution. They're saying that this law has to be struck down. So that's then results in case law where lower courts have to abide by that higher court's ruling. Now, the more formal methods of changing a state's constitution, there are legislative proposals where in this calendar year here there was 148 proposals and 106 of them were approved at that time. So that shows you how active the changes are at the state level on these constitutions, where on the federal level it may never change again when you look at how difficult it is to change. So obviously the vast majority of changes to constitutions are through this method, and much like the federal level requires a supermajority, 2/3 or 3/5 majority in order to make those changes in the state constitution. And there's another way in which the people can get more involved in changing the Constitution, and this is through the process of initiatives. And 18 states have this process that allows students to initiate and ratify changes to their Constitution, and therefore they are bypassing their state legislature. And this is fairly controversial, and as you can see, uh, less than half the states even have this, and it varies from state to state. There's a table in the book that shows you the number of signatures that are required for a petition in order to start this initiative, and it ranges quite a bit from 3% of the recent voter turnout to 15%. And initiatives, of course, because they are proposed at the grassroots level and could very much be driven by special interests and could be a subject to malfeasance. And there's been some examples of where initiatives got approved that were kind of a surprise, and then there was a lot of court action right after that to repeal it. Here's a chart. So as you can see right here, types of initiatives right there. Constitutional amendment. We see 18 states here that have this process, and what's also interesting is that all of these processes were adopted during the progressive era. So there has not been virtually any activity in the modern era as far as creating these initiative processes. So that brings up some questions as to how effective they are or how attractive they are. Some more ways of changing the Constitution would be a constitutional convention, which is also a method that the federal Constitution could be changed, but that's never been used not since the first ratification. A convention has never been used because the state legislatures are already there, so there's why create a convention when you've already got the state legislature? And that hasn't been used in any states since '92. So the voter approval of these proposals is somewhat problematic as far as voter turnout and the trying to get the word out as to detail in what's in these amendments, that sort of thing. And then constitutional commission is another way that at least could get it started to recommend changes to the legislature or to the voters. So this is an advisory capacity initiating change to the Constitution. that would require some sort of legislator or voter approval. Now, Thomas Paine, who wrote Common Sense, writing here about state constitution diversified and founded upon experiments tying variety in order to discover what might be the best. And so I've already talked about how our system of federalism does provide a lot of innovation. You've got 50 states that are handling their own business, and if they do something that seems to work, other states can use that and copy that, and it can even work its way all the way up to the federal level. And even though it's very difficult to do this, states are trying to move a little bit more to a higher law tradition to perhaps try to take out so much of the meaningless or no longer relevant detail and sticking to very basic principles. That's pretty difficult to do, and particularly when you have these initiative processes, that could be cluttering them even more, as well as kind of bypassing the legislators who we've actually voted for and hired and paid to do this type of job for us anyway. And the main thing here is that constitutions are difficult to modernize because they are considered the bedrock of that state law, and changing them is harder on average, even though they are changed quite a bit more than the federal government. It is difficult to, once you've got all that in place, it's difficult to modernize that. And here are some the websites there for additional resources. So that's talking about state constitutions. So what we'll look at next in Chapter 4 is looking at the election process.